I want to welcome everybody to Kent Presents 2018, a program entitled Where is the Supreme Court Headed? I'm Jim Zirin. I will moderate the discussion. With me are two very distinguished panelists. First, Sam Issacharoff, who is a professor of constitutional law at NYU Law School and is an expert, particularly on subjects related to the executive state, the unitary executive, the separation of powers. And we have Kristen Clark, who is executive director of the Lawyers Committee for Civil Rights Under the Law. I wish I had such an exalted and long title. And she is an expert, of course, on voting rights and how voting rights might be affected by decisions of the court in the current term. We've just heard a rather gloomy assessment of the way forward for our justice establishment, our traditional law enforcement values, and also a gloomy assessment for the rule of law. One institution that has the power to push back against an executive state is the Supreme Court. They've exercised this power sparingly. They did so when they invalidated President Truman's seizure of the steel mills and undoubtedly left open the possibility that there are extraordinary circumstances where the executive oversteps its bounds, violates the Constitution, and where the court can step in and restrain the executive's action. We are seeing that in this situation where we have a president who certainly has transgressed most of the presidential norms that we've been used to during our lifetime. And so we look to this institution, the Supreme Court, where the justices are unelected and where they serve for life and are thought of being independent of the political process and are said to be interpreting this 18th century document that we call the Constitution. And some of them think they should be interpreting it as it was written in 1789 or 1791, and others think they should be interpreting it as a living document which evolves over a period of time and adjusts to changing conditions. And there are justices who certainly differ about their approach to the Constitution. And we now see a Supreme Court which is at the watershed. Anthony Kennedy has retired. Jack Goldsmith, who's at Harvard Law School, who was the former head of the Office of Legal Counsel, has said that we were on the verge of perhaps the most transformative event in the history of the Supreme Court in our lifetime, with the replacement for Justice Kennedy. The presumptive replacement is, of course, Brett Kavanaugh, and the issue of who is Brett Kavanaugh, what does he stand for, is one that it will be examined in what is hoped is a searching and sensitive confirmation hearing. So, Sam, first question I have for you is, do you see Kavanaugh as the kind of swing vote that Kennedy was? Kennedy voted with the majority in the last 5 years about 89% of the time. And he showed that he was willing to vote with the liberals on issues such as abortion, affirmative action. He was certainly interested in partisan gerrymandering, although he voted with the majority there. But in other respects, he was a rock-ribbed conservative. But at least he was, when it came to gay rights, anyway, he voted with the liberals as well. Do you see Kavanaugh, who was the Kennedy clerk, as that kind of swing voter?
Well, I think that it's difficult to project Kavanaugh into the Kennedy mold because there tends to be a conflation of two different roles that the Supreme Court plays. In fact, there's almost two different Supreme Courts. If I were to ask the audience, how many cases in any given year, there's about 70, 80 cases the Supreme Court handles, how many are 5-4 conservatives versus liberals or Kennedy swinging? How many 5-4 cases do you think there are in a year? 20, 30, 60? The number's about 6 or 7. If I asked you how many unanimous cases does the Supreme Court handle every year, out of something like 70, 80, what would you think? The answer is in most years it's 40, 50, sometimes more. So the Supreme Court does two things. One, it handles the rights issues that are very contentious, very difficult: abortion, affirmative action, gay marriage, things of that sort. And on those, you have these strong cultural divides. It's a very small part of the docket. It's very significant. And more than that, it's very salient. Then there's another side to what it does, which is it just administers the laws. It has to figure out, does the bankruptcy code have 2 parts or 3 parts that are operative? Does a criminal sentence turn on the state of mind on one section as opposed to another section? And those are deeply, deeply boring enterprises. That's why we get paid to handle them, because you all don't want to be bothered with that kind of nonsense. And that's the divide on the court. But there's another function that the court does, which is, and it was touched on in the prior panel, we have a moment of constitutional crisis in this country because the Congress is failing as an institution. Our Constitution says, Article 1, the Congress. It's supposed to be the driving force of our government, and it has failed. It is failing. It cannot pass statutes. It is divided. It is weak. It is uncoordinated, which means that you have an executive which comes forward muscularly and says, we have agencies. We can run this country. We don't need no stinking Congress, right? And so they do it themselves. Kavanaugh is the most ideologically, intellectually formed justice nominee that we've had to the Supreme Court, I think, since Steve Breyer. Steve Breyer was an administrative law professor at Harvard who had a coherent view of how the administrative state works. Kavanaugh, what defines him is a vision that the agencies are out of control and they have to be scaled back, and government must be less. So we associate the Kennedy middle with the gay marriage cases. On affirmative action, he was always terrible, by the way. He always voted against affirmative action. On the Michigan cases, he voted against both cases on affirmative action. But on many social issues, he wanted to hold back. Let's wait. Let's see if it gets resolved. Kavanaugh, we don't know very much about him on the right side of things. But on the role of government in our lives, on scaling back the regulatory state, environmental protection, we know a lot about him there. And he's much more ideological informed and intellectually powerful on that than Justice Kennedy ever was, I think.
Kristen, where do you think Kavanaugh comes out on issues like voting rights and other civil rights that you're interested in?
So let me just start off by saying that I think this is the most important question that we all need to be asking ourselves right now. What's at stake with this Supreme Court nomination? And I think that we should all be gravely concerned about the nomination of Brett Kavanaugh for a number of reasons. During his time on the D.C. Circuit, we've gotten a chance to learn who he is. President Trump on the campaign trail said over and over and over again, I will appoint justices to the court who will overturn Roe v. Wade.
Automatically, he said.
Yeah, and in one of the most controversial of his decisions earlier this year, he blocked an undocumented teenage girl in Texas who sought to be released into the care of a guardian to get an abortion.
He is Kavanaugh.
Kavanaugh. He is somebody who is fully prepared to execute on Trump's goal of appointing justices to the court who will overturn and gut Roe v. Wade. I think that you're exactly right. He is also somebody who is focused on gutting the work of our nation's federal agencies. Our federal agencies, the Justice Department, EPA, HUD, the Department of Education, all carry out incredibly important work. These are the agencies that breathe meaning into the text of laws passed by Congress. In one of the most telling cases in his record, we see him setting his sights on tearing out the heart of our federal agencies. There's a case called Homer versus EPA. This is a case where Brett Kavanaugh found a rule dealing with pollution that cuts across state lines. The EPA kind of said, you know what, we've got to get a handle on, the bad actor states that pollute in ways that harm good states. They put in place a rule that they found would have prevented premature deaths, tens of thousands of premature deaths. Kavanaugh found the rule unconstitutional. That case went to the Supreme Court and was reversed by a margin of 6-2. Justice Kennedy joined with the majority. Justice Roberts joined with the majority. And who was in the minority? Thomas and Scalia. Brett Kavanaugh will absolutely hijack the court and tilt the balance of the court for generations to come, if confirmed. Everything in the record suggests that he is somebody who will not be a moderate, who will not be fair, who will not impartially evaluate the cases that come before him. He is somebody who is squarely aligned with Justice Thomas and the late Justice Scalia.
But, Kristen, let me ask you the question this. The American people elected Donald Trump, for better or for worse. He presented himself to them as someone who would appoint justices to the Supreme Court in the tradition of Antonin Scalia, and justices who would automatically overrule Roe v. Wade, and then he's elected. And he gets a list of justices from the Federalist Society. And on the list are a number of judges or non-judges whose intellectual qualifications would pass almost any standard, but they are ideologically people of the stripe that he promised he would appoint, rather than the stripe that you or perhaps I might like. Now, isn't that exactly what our Constitution intended?
Well, the Senate plays an important role in that process, and the Senate has a job to do right now, and that's to carefully evaluate the qualifications of Brett Kavanaugh and determine whether he is somebody worthy of one of those 9 seats on our nation's highest court. This is a lifetime appointment, and the Senate should not merely rubber stamp President Trump's nominee. And they shouldn't do so for a number of reasons. We've seen some awful nominees come out of the White House during President Trump's tenure. Many of you will recall Mr. Peterson, whose nomination went down in flames after some grilling by Senator Kennedy out of Louisiana, a Republican, who asked him some really basic questions. And he confessed, hey, I haven't done a lot of trial work. I don't know much about the federal rules of evidence. Daubert standard, haven't heard it. I mean, he was up for a seat in the D.C. Circuit. This is a stepping stone to the Supreme Court and one of the most important courts in our country. Ryan Bounds out of the Ninth Circuit, and I wanted to read, from some of his writings verbatim. This is somebody who was up for a seat on the Ninth Circuit. Fortunately, his nomination was voted down. He wrote in writings that surfaced during his time at Stanford University that multicultural organizations on campus, quote, divide up by race for their feel-good ethnic hoedowns. He described race-focused groups as not necessary, and said white students, after all, seem to be doing all right without an Aryan student union. He made very insensitive remarks about women who were rape victims on campus. He said expelling students is probably not going to contribute a great deal toward a rape victim's recovery. He decried sensitivity towards racial minorities in the LGBTQ community and activism by those communities as, quote, a pestilence that, quote, stalks us and threatens to corrupt our scholastic experience. As a civil rights lawyer, there is no way I could ever expect to stand up in a courtroom with someone like him presiding, expect to get a fair and impartial chance. A chance to be heard, and a chance for a judge to say, you know what, I've evaluated the facts, and I've carefully evaluated the law, and here's my ruling. There's no way a judge like this deserved a lifetime appointment on our nation's highest court. With this track record, it's important that the Senate right now do its job and turn the record underlying Brett Kavanaugh upside down to understand who he really is. And they can't do that because right now we see folks in the Senate who are hijacking the rules, changing the rules of the game that have long been in play for how we have evaluated Supreme Court nominees, whether we're talking about nominees that emerged during Democratic or Republican administrations. When Justice Sotomayor went up, Chairman Grassley said, I want every record from her time on the court, and I hear that she sat on the board of a civil rights organization. I want the minutes for every meeting that organization held. And you know what? They turned it over. Justice Kagan, same thing. They demanded 100% transparency. They wanted records and documents from her time in the administration, and they were turned over. Brett Kavanaugh served several years in the White House, many of them standing shoulder to shoulder with President Bush. And Chairman Grassley right now has changed the rules, double standard. He's announced a September 4th hearing, even though hundreds of thousands of documents
Only 13% have been turned over.
Have been disclosed. We need those documents that speak to issues like torture and civil rights and executive power and the issues that we know Bush well handled during his time in the White House and that we know Brett Kavanaugh had an influence on. But they're hiding something. And Chairman Grassley, despite this, is raced forward with September, a confirmation process that's supposed to be on September 4th. I think this is an absolute travesty. I refuse to be distracted by drama over Omarosa and the insults levied on LeBron James, because I think it's all a distraction from this. And this right now is the biggest fight that we face in our country, and our democracy is at stake, because without balanced courts, there's no way to check the abuse and excesses of the other branches of the government, the executive branch in particular.
Sam, how does Kavanaugh stand on the separation between church and state? He is on record as favoring a school vouchering system whereby federal funds and state funds can be used for parochial schools.
From everything I know about him, he thinks that the line inherited from some 1960s cases on Establishment Clause and on some of the free exercise issues are wrong, that that line is wrong. It is something that I may not agree with. I have to say I don't find this particularly shocking. There is a great deal of sophisticated analysis that also questions the vitality of those cases. They are not the positions that most academics would endorse, meaning the Kavanaugh position is not one that most academics would endorse. It's not one that has captured most of the courts thus far, but it's not outside the range of what's there. If I could just respond a little bit to what Kristen said a second ago. I think that what Kristen sets out is a very strong, coherent position on why this is the realization of a vision of America that is an anathema to many people. It is threatening. It is disruptive of the way we have seen this country and its legal institutions develop. It's consistent with the assault upon our legal institutions under the Trump administration. At the same time, if one wants to make a predictive matter, when you have a president with a majority in Congress, Supreme Court nominees go through, absent extraordinary infelicities on their part. And Kavanaugh would not be my choice for the Supreme Court, but he's not unusual. I could not say that only in a Trump administration would you have a Brett Kavanaugh appointed to the Supreme Court. I think only in a Trump administration might we consider having Judge Judy appointed to the Supreme Court. But Kavanaugh would be at the top of the list of any Republican president at this point, and Kavanaugh would sail through any Republican Congress because he is a certain kind of movement conservative that grew up around the Federalist Society. Now, what I find scariest about him and what I really don't have a feel for, I think, I agree with Kristen, if Kavanaugh's there, Roe versus Wade is going to be eroded and eroded and eroded, and it's not going to be likely to be by fiat of the Supreme Court. It's going to be these death by 1,000 cuts from the state legislatures that the Republicans control, and the legislation produced by this organization called ALEC that gets passed by state after state, and the Supreme Court will stop holding it back, and that will be the end of Roe versus Wade. As a practical matter, largely that's already happened in many parts of the country today. I think that there will be further erosion on the rights issues, not probably on gay rights, because the consensus has been so broad in our society, it doesn't even seem to be a talking point among conservative candidates. But let's go back a little bit in time. Let's go back to the 2000s, after 9/11 in the United States, when you had a really scary assertion of executive power in the United States, when you had an administration that says, we have the right to proclaim an emergency, basically suspend a whole lot of laws, decide how long the emergency is in place, decide if and when it ends, and basically run everything through the executive branch. The institution that pushed back against the executive was not our horrible Congress. It was the Supreme Court. And the Supreme Court handed the Bush administration one defeat after another, maintaining the rule of law, including Justice Kennedy, including Justice Scalia on occasion, including, there were near unanimous courts saying you just can't declare that the Constitution is no longer operative. This is America. And that was a heroic moment for the Supreme Court, and it was a conservative court that did it. Would Brett Kavanaugh support those decisions? I don't quite know the answer to that, because he has a limited role of government as a main objective, but I'm not sure if he understands the importance of the courts being a break upon this seizure of power by the executive in our country. And this has been going on for decades now, under Republicans and under Democrats. Expansion of administrative authority, expansion of the right to rule more and more by fiat. This is threatening stuff, and the court has been very good at policing the boundaries of that. I fear that that's what really is at risk right now. It's not a great talking point. You're not going to raise money. You're not going to run ads on this point. But if I had to say what my worry was in the Supreme Court going forward, it's that loss of an independent check upon executive power, made all the more important when we have a simply out-of-control executive. This is the most out-of-control assertion of executive power, what's going on right now, that we've had in this country since Andrew Jackson. It is simply a claim that if the president mandates it, it is so. And the court has to be there to stop that.
Well, by way of example, in the 1930s, I think it's the Kingsley case, Franklin Roosevelt fired the chairman of a federal regulatory commission. And the Supreme Court said no, he didn't have the power to do that. It was Congress that set it up as an independent agency.
Well, to go
Kavanaugh has said he disagrees with that decision, and it should be overruled after all these years. And he thinks the president is the chief executive under the Constitution, and that any law of Congress that tries to establish an independent agency is unconstitutional.
There's an important case out of the D.C. Circuit that's very similar to what Kristen was describing, where the Congress set up the Consumer Finance Protection Board, and it set it up in such a way that the head of the CFPB can't be fired unilaterally by the president. There have to be findings and so forth. It went to the D.C. Circuit en banc, which means all the judges heard it, and the majority, Judge Pillard, wrote a very fine opinion saying, we've had these kinds of agencies since the 1930s. It's an important check on the president's power to make sure that he can't just get rid of the head of the agency at will. And the dissent, very strong, very coherent, written by Cavanaugh. And oddly, because Cavanaugh may be on the Supreme Court, the court will probably divide 4-4, which means that opinion survives and the CFPB survives, but only because he has to recuse himself. Because I think that that vision of the president can do and Congress cannot is is a scary one in this time.
Well, let's move to Kavanaugh's impact on the Mueller investigation and possible prosecution. It is certainly conceivable that negotiations will break down for Trump's voluntary submission to questioning from Mueller, that he may try to serve a subpoena. The president moves to quash the subpoena, and it goes to the courts. Kavanaugh is already on record as saying the president should be immune from criminal prosecution and investigation, even though recognizing that he is not, despite this regulation or opinion of the legal counsel of the Justice Department. And when issues such as this, which may well arise, reach the Supreme Court, and they certainly will if they do arise, what do you expect Kavanaugh will do?
I think this is a really hard one. You tried to press me to come up with a conclusive position when I was on your TV show, and I ducked it successfully. And
well,
I guess
there I was in charge. So.
This time, there's two separate issues. One was Kavanaugh was part of the Starr team. Now, the Starr investigation was under a statute whose constitutionality was upheld. Some of us have had second thoughts about that, but Starr was under a statute that gave him an independent role of authority. Now you have an investigation that's done under the aegis of the Justice Department. And so the president is in charge of the Justice Department, and there are all sorts of regulations in place that prohibit him from acting on Mueller directly. What that means, folks, I hate to tell you this, is that he can't sign an order firing Mueller. He has to sign two orders. The first one saying, I abolished the regulation that protects Mueller, now I fire Mueller. So it's not a great world here that we're dealing with. It's a precarious world. That's one side of it. What's the authority that Mueller has? The second side of it is, what's the power over the president? And I think that the Constitution really wanted the president to be accountable through the political process to the institutions that are ultimately accountable to the American people. That means if the president is elected, the people who are in charge of removing him and disciplining him are the Congress. And unfortunately, our Congress is no good. I mean, that's the bottom line. It's not playing its role. It's not holding investigations. It's not meaningful. And it's not playing that role. So what happens if Mueller tries to indict or prosecute Trump? I agree with what was said in the last panel, for those of you who are here, but the Office of Legal Counsel got it right. The Constitution anticipates that the president has to be removed from office by the Congress. He can't be henpecked to death by a prosecutor here, a state attorney there, somebody deciding I'm going to chew up his time by starting to prosecute him. They didn't want that, and they wanted this to be a political act.
But isn't it for the courts to stay such a prosecution if it were brought? I mean, suppose they indict him. I think the judge would say that he can't be distracted from the presidency.
I think a judge would say that. I think a judge should say that. I cannot imagine Mueller indicting. Well, I can't imagine Mueller trying to bring the president to trial. Whether Mueller could indict and park an indictment, that could be done, And then I think that there would be nothing operational at that moment in front of any court, and the courts would probably say this should be resolved in the first instance by Congress, or it can be resolved if the prosecution is ever to go forward. That would be kind of an abstract decision that the courts are not likely to get involved in. But the question you asked is the hardest one, which is, what if he is subpoenaed? And we know from the Paula Jones matter that a president can be forced to sit for a deposition in a civil case. It follows from that a president can be forced to give testimony in a criminal case if a court is persuaded that it is important, that it can't wait, and so forth. And I think from the Nixon cases, which Kavanaugh has criticized, but I don't think he would overturn directly, I think that that this would not be ultimately reviewed by the United States Supreme Court. I think a court would, the lower court would say, you sit and you provide information.
Well,
A more definitive answer, though, to this question is buried in the hundreds of thousands of documents that have not yet been disclosed from Kavanaugh's time at the White House. So I just want to be sure to underline that point. And I also want to make sure that we don't get too bogged down in the Mueller investigation and President Trump's fate, because this nomination has enormous implications for the American public generally and broadly, for women who care about preserving Roe v. Wade and care about reproductive justice, for immigrant rights, for people who seek gun control in our country. I want to make sure that we don't lose sight about the broad implications of this nomination and how it stands to potentially transform our democracy. You know, the March for Our Lives, I think, was a really historic moment several months ago that has sparked reform, a movement across the country where young people are pushing for gun control. And I think it's an amazing thing. And even here, Judge Kavanaugh has a clear record that makes clear that he is somebody who would bring to bear the most expansive view of the Second Amendment imaginable. In Washington, D.C., after a Supreme Court debate on D.C.'s earlier iteration of a law that banned handguns, and the Supreme Court struck that down, D.C. came back and said, okay, well, we're going to ban assault rifles in our nation's capital and magazines, that we don't want people walking around with loaded up with ammunition and rifles inside our nation's capital. And even here, 2-1, Judge Kavanaugh ruled in dissent and would have struck that law down as unconstitutional. So in every area, voting rights, reproductive rights, gun control, he is somebody who is an outlier. He is somebody who's outside the legal mainstream and would, I think, issue rulings that would really transform our country in very harmful ways.
How do you account for that? He professes to be a textualist and an originalist, and the Second Amendment has a preamble which does not state that there's a personal right to bear and keep arms, but only within the context of a state militia. And a judge is supposed to give effect to every word in the document, not just can't pick and choose.
Yeah, I think the textualist label is an easy label to hide behind, but at so many moments we see, you know, Justice Alito and justices on the court working by any means necessary to arrive at the ends they want to achieve. And we saw that this term with the union case that required the court to overturn longstanding precedent. And did so without a real or significant basis. There wasn't any real or factual basis. And issued a ruling that I think will really gut the heart of unions in our country for years to come, public sector unions in particular. So I think it's just a label, a mask, and that you have judges like Judge Kavanaugh that will get to that ends by any means necessary.
Well, quickly, and we can get to the Q&A because I know you all have questions for the panel. How do you see Kavanaugh standing on capital punishment?
It's a good question. I have not seen anything in his record from his time on the D.C. Circuit, but I do think that if we get the hundreds of thousands of documents from his time at the White House, we might find something that reveals his thinking on this
Scalia
question.
said that his position on capital punishment was in part informed by the language of the Constitution, which plainly contemplates capital punishment in the Fifth Amendment, but also by his Catholicism, and he gave a theological explanation for why the state is authorized in certain circumstances to take a life as a form of vengeance. Kavanaugh will join 5 other justices who are Catholics on the court. The Pope has changed his stance on capital punishment. Do you think that will influence Kavanaugh's jurisprudence?
His faith. I think it could. And as we sit here talking about the death penalty, I also think about solitary confinement.
Which Kennedy was very much opposed to.
Absolutely, and it was inviting a case on solitary confinement, and I think would have presented a really interesting moment for the court to take up the question about the legality and appropriateness of confining young kids.
Okay, let's
for
open
long
it up.
periods.
Questions for our panel? Please go to the microphone and
Hi.
wind up and pitch.
A very basic question. How's the docket of the Supreme Court determined, and what role does the majority, particularly if Kavanaugh is appointed, play? We recognize what it plays in decisions, but how does it affect the docket that the Supreme Court determines to put on?
Well, there's 2 answers. One is the formal answer and one is the real answer. The formal answer is that there's about 10,000 petitions for Supreme Court review presented every year, and other than a very technical glitch, basically they pick what they want to hear out of those 10,000. And they pick, it used to be 150, 160, it's been down to about 70 for the last decade. Justice Breyer says, well, Congress isn't doing anything. Most of our docket is reviewing new statutes. We don't have any new statutes, so we don't have much work. And there's some truth in that. The other answer is that on the high-profile issues, the justices signal in their opinions what they want to hear and what they're interested in hearing. Kristen just mentioned that Justice Kennedy said, I'd like to hear a case about solitary confinement. It didn't come up while he was there. And so that affects how people set up high-profile or what we consider public matter cases through the court system in order to get it to the Supreme Court. It only takes 4 to take a case, and so it's unlikely that there will be a big shift in what the docket is, going from Justice Kennedy to Justice Kavanaugh, if Judge Kavanaugh is confirmed. I think that won't be where you see the big change in any short time frame.
But I will just also add, 99.9% of cases get heard by the lower courts, by federal district courts and federal circuit courts. And it's really just a few dozen cases that are heard by the U.S. Supreme Court, which really underlines the point that the Supreme Court is special. This is the nation's highest court. Those 9 justices on the court should be able to meet the highest standards when it comes to being people who will be fair and independent and able to forge coalitions. You know, you think about Brown versus Board of Education, a 9-0 ruling, and it seems unimaginable today that in a civil rights case that is so gravely consequential that we'd see a margin like that. We don't want the Supreme Court to become more polarized than it already is, and I think that's one thing that we have to keep in mind with the Kavanaugh nomination.
It's interesting that Roe v. Wade was a 7-2 ruling, which would not have been possible without the votes of 3 Republican-appointed justices, Berger,
Yeah.
Blackmun, and Powell.
Yeah.
So there used to be more of a perception of independence in how the justices voted than there would appear to be now, where they seem to be appointed for ideology, confirmed because of ideology, and then they get on the court. And as we've seen with Gorsuch, really singing for their supper and doing exactly what the administration intended them to do.
And one of the justices in dissent in Roe v. Wade, Justice Rehnquist.
Yes.
And who was Judge Kavanaugh recently issuing a speech about and lifting up? Justice Rehnquist. Further indication that he is somebody who will chip and gut away Roe v. Wade.
Yes, ma'am.
First, thank you. This is incredibly interesting. And I want to ask a question that may sound a little bit too abstract, but it has to do with something that came up in the last panel. There was a comment that the greatest victim of the current administration is the idea of truth and objective truth. And I wanted to ask about where you see the court going in terms of who owns truth, because literally we have Congress making statements in the preambles to its bills that are simply false, and you have an executive branch that's been feeding objectively false information. You can talk about whether it's climate change or it's reproductive, the reproductive effects of a particular procedure, whatever. And you have independent agencies who, up until now, have been given some degree of deference when it comes to factual findings, but we're also seeing an attack now on the idea of evidence-based rulemaking out of things like the EPA.
So what's the question?
So where the question is, where is the ownership of truth going to come from under this new court? I mean, is there going to be a preference among institutions, or is it going to be entirely partisan, either Congress or the president, or is there a conflict between them? It's just trying to figure out how to trace it. And last, and I apologize for how long it is, even the court itself has had a trouble with the notion of facts, because they're getting all these amicus briefs that make assertions that they then cite in their opinions without ever having vetted them or having cross-examined them. So that it worries some of us who do evidence-based policy that we don't know yet who owns the title of "I know the truth."
I think that we spend a lot of time analyzing the cases that are the highest profile. And sometimes the cases that are lower profile reveal whether an institution is working well or not. Everybody fails under high stress. So you get Bush v. Gore, you get kind of crazy actions. The presidency's on the line. They're making decisions after midnight. They're all over 80 years old. They don't function well. At 10 p.m. by midnight, it's all over, you know. And but I think that the Supreme Court, and here I'm going to be stupidly an optimist, the Supreme Court is still an extraordinary institution that people in this country should be very proud of. You had a case last semester, teacher on. I taught last semester. No, sorry. A case last term that was called the Carpenter Case, and it had to do with triangulation of where people are from their cell phones, because the police know where you are all the time. Do you have an expectation of privacy and all that? So it's a new issue, a new technology. It goes to the core of protecting citizens, which is what the state is supposed to be about, but it also potentially intrudes on our privacy in ways unheard of. The court divided all over the place on that, and each opinion was more intelligent than the one before. They worked through a really hard problem. You can agree, you can disagree with where they came out, but you read that and you think, these are people who are trying faithfully to do their job. So I think that we should not succumb to the easy cynicism that they're all partisans. They don't, it's all fake facts, it's all fake news, it's all fake law. It's not. For the most part, they're really trying to do their job. And I think that one of the points of stewardship of Chief Justice Roberts is that he has a sense, now I don't know whether this will prevail in the long run or not, but he has a strong sense that this is an important institution that he's in charge of, and that if you give that up on your watch, you have committed a historic betrayal. And I think that keeps him up at night. And when you read something like the Carpenter decision, you see an institution that reflects in many ways the best of our country.
But how do you answer the point that in the area of the rights cases he referred to, the minority of cases with the outcomes that we all care about, that these are 5-4 decisions, sometimes 6-3 decisions, but largely 5-4 decisions, with the 5 Republican-appointed justices voting one way and the 4 Democratic-appointed justices voting the other way?
Jim, you're not going to like this answer, but that's how it should be. And that's exactly what the constitutional framework sort of set up. Because what a Supreme Court justice is the distilled politics of the moment of appointment preserved in amber and going forward until they die. And what that means is that when you are at these cases, And we can disagree about how many of these there are, but when you're at these cases where you're talking about fundamental things in our society, hard rights issues, where have we moved this far? Should we move further? Is it going to alienate part of the population? Is it going to raise people in rebellion? At that point, the Constitution runs out. I'm sorry, it just doesn't tell you the answer. So what do we turn to as a democratic society? We turn to our distilled politics. The court is supposed to be a conservative institution, and when it's ready to move, it's the time of Brown, because segregation could no longer be tolerated under any circumstance. Now, I think that should have come way before, like 100 years earlier, but that's a matter of conjecture. When it does Roe v. Wade, when it does Bergfeld, the gay marriage case, these are the moments. But when it has to confront these issues, it's going to divide along political lines, and we pretend that we're all balls and strikes and all this. We all know the facts. We all know that the Constitution, these few words written hundreds of years ago, can't possibly control everything that we have to confront as a society. And that's just, my view is that's life.
I want justices who are fair and impartial and uniform in their approach and willing to conduct a searching examination for the truth and leave no stone unturned in their work. I believe that we can have courts that are free of partisan taint and all of this political, hyper-politicization that infects our Congress today. And as a civil rights lawyer, I won't ever give up on that, and I will always keep fighting for that. And, I think about this question about kind of what is truth. And, I thought about the Muslim ban case, which I thought was an interesting moment for the court this term. Right there, the court turned a blind eye to the truth and said, we're not going to give any weight to the tweets. The President Trump's tweets made clear what infected and motivated the Muslim ban, and they chose to read the four corners of the document saying, no, this is all for foreign policy and security, national security reasons.
Same rationale they used in the Japanese internment case,
Yeah,
where they were misled by false affidavits.
Yeah, democracy fails when we don't demand more from our courts.
Well, I think in that case, they were prepared to ignore what Trump had said during the campaign, that he wanted to ban all Muslims from the United States. And I thought Justice Kagan asked a very telling question in oral argument where she said to the government lawyer, suppose we had someone who ran for president who was a hardened anti-Semite, and he got into office and he banned all immigration from Israel. Would the Constitution be implicated? And the lawyer said, oh, that would never happen, Judge.
I'm curious how the Federalist Society came to be the Federalist Society and became the arbiter of what stands for conservative thought and has managed to really impose itself upon at least every Republican president to serve up who's going to serve and who's not going to serve. There was a time in my lifetime when presidents got the advice of people around, and so they would ask this guy and that guy and, sit at their golf club and listen to their golfing buddies tell them who should go on the court. And there was no organized system for establishing purity. So how did this happen? I also will note that the Democrats are clueless about this and have nothing to even begin to offer in any kind of opposition to it.
Okay, do we have a quick answer to that one?
So when I was a law student at Yale, graduated in 1983, I had a professor for con law, Robert Bork, who was an inspirational figure for a number of students, and a classmate, Steve Calabrese, who founded the Federalist Society. And it was trying to bring ideological coherence to the Reagan Revolution. And they succeeded. They were intellectually bold. They were, right from the beginning, fearless and willing to do debates with people who didn't agree with them. and they captured the agenda because they developed an intellectually coherent line.
They
And
captured the agenda. Unfortunately, our time has run out. What a wonderful note to end on.